About the Outer Space Treaty. So, firstly, the Outer Space Treaty is treaty on principles governing the various activities of states while they are exploring the outer space, including the moon, the celestial bodies, right? And this was the resolution which was made and which was adopted with all the United Nations states. And with the declaration, the treaty was opened up for signatures, and this came into in force in 1967. So the treaty is though not binding on all the states, right? But the very basic idea to all the states is that the rules regarding the outer space has cropped up, and as a customary rule of international law, they have to follow them. So the treaty was approved, in order to regularize various aspects. And this was the landmark towards, there was a landmark set up, or you can say an established legal regime of outer space. So what is constituents, or you can say the very idea or the content of this treaty, basically. So the first thing that was related was about, it prohibits countries from placing into orbit around Earth any objects that are carrying nuclear weapons or any kind of weapons of mass destruction. So no outer space body can have any object that carry nuclear weapons or any weapons of mass destruction. Also, it requires the celestial body shall be used by all parties exclusively for peaceful purposes, and no weapon can be stationed on them. So, in order to prevent arms race in space, they had to set up these ideologies or had to set up these agreements before, there are so many celestial bodies that are sent to the space. So, this was to regulate and, encourage disarmament into the outer space. So India ratified this treaty under the agreement in 1982. So these were the very first. First is regarding the freedom of exploration of outer space. So Article 1 of this particular treaty provided that the outer space, even including of moon and other celestial bodies, shall be free for all exploration and use of all the states without any discrimination of any kind. And it should be in accordance to the basis of equality and in accordance with the international law. So there shall be free access of these celestial bodies to all the nation states, right? And also it provided that it should benefit, and you can say they should help encourage other nation states to take aid from this, and also this should be in interest of all the countries irrespective of their degree of, you can say, economic levels, or you can say developmental levels, the social developments, etc. Because this treaty had an ideology to be there for all mankind, right? So this proposition or this provisions of this particular treaty on outer space had, explored the freedom of exploration in the outer space. So they have a right, nation states have a right to launch objects into the space, the freedom to explore and, do conduct research, and also while respecting other nation states' rights and interests, they should try and explore and limit their usage in accordance to the principles. So this is analogous to the principles of freedom of high seas that we had discussed in Law of the Sea, if you remember. It is equivalent to high seas, which are open to all the nation states. And everybody has a right over the high seas, that are the oceans, right? Is it clear, the first contention of this treaty? Yes, class? Class, are you there? You listening? Bache, is it clear? Nobody is listening.
Ma'am, it's clear, ma'am.
Anyway, so the next that is contention is the peaceful usage or peaceful uses of outer space. So the next part of this treaty deals with, you can say that this treaty provides for that the outer space, the celestial bodies, the moon, and other planets, etc., shall be used by the nation states exclusively for peaceful purposes. They'll not conduct any nuclear test, or they'll not conduct any military expeditions, or they'll not attack or encourage any installations or any fortifications or any weapons or any nuclear weapons into these objects or space, right? So that is what it is prohibited and forbidden. So the fundamental prohibition of war, its propaganda and encouragement of disarmament, shall be applied in the contention of outer space as well, right? So this treaty undertake in the orbit the Earth and any objects carrying out any nuclear weapons or kind of weapons of mass destruction and installation of such weapons into the satellites or other celestial bodies that are sent to the outer space is completely prohibited and forbidden. So the provisions in this way are permissible to place, to station the celestial bodies, the satellites into the orbit around the Earth or around any other planet or around the moon. And however, such weapons, are not, the weapons are not to be sent. The provisions are only permissible to satellites positioned or placed or stationed amongst the orbits. Right? Is it clear? And the next is about the jurisdiction. So what is jurisdiction of states over these objects that are launched? So this treaty had defined, while we talk about registration of these objects. So the state party, who is the signatory to this particular treaty, the nation state, on whose registry an object is launched into the outer space, shall carry out and retain jurisdiction over its the particular stationed object into the space, and shall possess control over them and over any personal thereof while it is in outer space or in a celestial body. So the ownership of objects launched into the outer space is not affected by their presence in their outer space or where are they stationed in the outer space. So that is from where it has been registered. It is done through the registry. Is it clear? And if their station is not defined in their registry, they'll be sent across, they'll be identified, and then thereafter they will be sent and they will be returned to the state from where they have taken off, right? And last, about their international responsibilities. So while there is some error, this treaty also defines the state's international responsibility for all activities in the outer space, whether they are carried out by their government or through non-government agencies, the activities in the outer space by any international organization, the is completely with the nation states who has owned the name, the usage is being done through that particular space object. And if there is any damage or if there is any, obligation that is in relation to that particular satellite or celestial body who has harmed any other nation state. So the satellite who have the country, the nation state who has sent that satellite will be solely responsible for any damage that that particular satellite has done to any other nation state. And through negotiation, arbitration, etc., conciliation, they can mutually decide and compensate for the damages caused to another nation state by their satellite or any celestial bodies that are registered with name. Is it clear, class? So the whole ideology of this particular treaty is to promote international cooperation while using the address, right? It also encourages, you can say, um, in providing various limitations for nation states to send their the celestial bodies across the orbit and across the outer space. Right? Any questions for this particular convention, the treaty or outer space, 1967? Any doubt? No response, class?
No doubts, ma'am.
Okay, perfect. So after this, right away in 1968, in this particular treaty on outer space, there was a definition of an astronaut, and they tried to incorporate uh, the astronaut as an envoy, or they tried to, assist the astronaut while they had sent the person into the space as an envoy. This person was called envoy, and thereafter the term astronaut had emerged, and it was sent to the outer space, right? And while there was any accidents or there was any emergency or there was any emergency landing which was to happen or there was any distress, uh, you know, to whom that astronaut had belonged. So while this astronaut had to make such, emergency landings or there was an accident, they shall be, safely and securely sent to the place they belong to. This has been compared, the astronaut or the envoy of the mankind has been equivalently compared to which we learned about, the consuls as well as diplomatic agents. So the similar rules were to be applied to astronauts. There may be some incident or some accident that they have to land immediately on a particular nation state, right? So these astronauts were given a priority, they were given help and additional assistance to the personals that were running that spacecraft, right? And such accidents or such emergency or unintended landings, while helping them out for their activities they conducting in the outer space, they were helped out. The assistance were given to the territory of any other state or state party that had, they had to make a immediate landing upon, right? So this agreement, this treaty had started out with this basic idea of helping these astronauts while they had to do an immediate landing. So right after this, in 1968, there was a complete convention that, so this was to rescue, return of astronauts as well as objects that were sent to launched into the outer space, right? So agreement was about to undertake and provide assistance if it has received any information or discovers that the personnel of a spacecraft had an accident or is experiencing some kind of problem or some kind of emergency and intends to land in a particular territory which may be not under its jurisdiction, or maybe it is in the high seas or any other place of any state. So such states shall be immediately notified, right? And the launching authorities there should be public announcement, and all the appropriate means of communication or ends of disposal had to be identified, and you know, through the Secretary General of UN, they should provide the information as well as ensure that these astronauts are rescued and they are returned safely, and also pretext of any space object that can be returned to Earth on a easier space or easier pace, not in its own territory, can also land into any other nations through this particular agreement. Particular clear class? Yes, class, is it clear? So the next convention is about international liability for damage caused by space objects of 1971. So this convention provides for rules and procedures that are concerning the liabilities of states who are launching them, and for the damage they had caused to any damage caused by their space objects, right? So this convention ensures that it is prompt as full compensation for any damage that has been caused by any space object on any surface of Earth, or to any aircraft, or to aircraft which is in flight, right? So any damage that has been done, the state who has launched that particular space object has to compensate to that damage, whether it is on the territory of the Earth, maybe is it damage to any aircraft which is standing, or any aircraft which is in flight. Expression damage hereby is about damage means loss of life, maybe some injuries caused to people, or impairment of any health, or any damage of loss or loss of property, you know, or any persons or any properties or any governmental or intergovernmental organizations, right? So if any space object has damaged, which has been launched has damaged, the state shall be jointly as well as severally liable for any damage that has been caused. The convention also provides for establishment of claims commission in case there is no settlement between the states to which the damage has been caused and the launching state. So the launching state is to bear the international liability for any damage that has been caused by the space objects. For example, if I tell you there was a case that was related to and this case was, let me name of the case. I've not written it in this PPT. Okay, let me tell you the facts first, then I'll write down the case name. So in this case, basically a part of a debris or a satellite, a part of satellite which has floated in the space, uh, landed up and came up. Uh, it was there in which has landed up in a particular state territory of a country, right? And thereafter there was uh, there was a lot of damage right? And there was damage that because of that artificial object, or you can junk which was sent, that was the part of the space object which was uh, smashed into a particular area, right? So in that context, that is called a debris, a part of a particular celestial body or a particular satellite. For that there was damage to loss of property as well as life, and a lot of people were actually had there were a few killings also. So what happened thereafter? So because of that, maybe some malfunctioning had happened, and there was that was contended that that particular debris was radioactive that was having some nuclear power into it, or maybe it had activated itself while it was crashing down. So what was the liability in that context? What is the international liability of the country which it had set? Let me write the case name for you first. So this is Cosmos 954. This was a Russian satellite. Which was uh, which landed up in in the territory of Canada, northern Canada. So what in this particular case? So the very first contention was, while talking about the liability convention, this was in question, right? So this convention of 1971, the space convention, it is famously called. So, Canadian government had billed Soviet Union, the Russian government, for around $6 million and additional expenses and compensation for unpredicted expenses as well, because there was a lot of hurt, as well as there was damage to the life, as well as damage to the property of the country of Canada. So after there was, the compensation was to be, arbitration was held. There was, mediation between the two nation states. And finally, USSR had to pay $3 million. That is approx half of what was claimed by them. Okay. So this was about the international liability of damage that can be caused by any space object, and the state to whom that space object belongs to shall have to compensate for any loss of property, life, or any organization to the nation state who has got the damages. Right? Any questions up till here? Yes, class?
What is the name of the case?
Chat box, can you see?
No, ma'am, it's not visible. That's why I told you. Ma'am, can you type it again?
Is it visible now?
Ma'am, now it's visible, ma'am.
Right.
Ma'am?
Oh, Yes. Okay.
Can you upload this PPT, ma'am?
Yeah, not uploaded.
No, ma'am, it's not uploaded, ma'am, in Teams.
Also, I think it's already time. We'll continue Monday, right? So, it is uploaded. At the time, I'll take the attendance. So we are just left with half of the conventions. We'll discuss about registration of the objects and also drafts of various, what do you call this, space objects, draft principles which are yet to be formulated, and unispace conventions. 1, 2, and 3. And last, we'll talk about moon and other celestial bodies and the moon treaty in particular. That is very small, like half an hour lecture is left. So on Monday, we'll start a new topic as well. So you want me to start with the two topics which are left are, let me tell you. One is about the methods of creation and peaceful methods of, and the next topic which is left is, let me open the and information. Uh, Probably
Your voice is
14.
breaking, ma'am.
So
Your voice is breaking, ma'am.
now, hello, I'm audible now.
Yes, ma'am. Yes, ma'am. It broke, ma'am, totally what you were saying.
This on Monday. Probably I was asking you what with you.
Again, it broke, ma'am.
Uh,
Ma'am, not audible.
and, uh,
Sorry to say, ma'am, interrupt you, ma'am. It's totally
okay,
breaking, not audible at all, ma'am.
So class, have you received the PPT?
Ma'am, in chat box is visible, ma'am.
Okay, perfect. We'll talk about the next two parts on Monday, right?
Yes, ma'am.
Have a nice day. Have a nice weekend.